Good morning, everybody. Welcome to the ANZOG National Regulators Community of Practice and our inaugural HARASSMENT SA chapter event. So thank you for those who attended in person, and welcome to everybody online from wherever in the world that you're viewing from. I'd like to start this event with an acknowledgement to the traditional owners of all the lands in which we meet today. For us here in Adelaide, I acknowledge the Kaurna people as the traditional owners of the Adelaide Plains, and I recognise their cultural heritage, customs, spiritual beliefs, and relationship with the land as ongoing importance today, and I pay my respects to elders past, present, and emerging. I also pay my respects to all First Nations people present today, both in the room and online. I'd also like to welcome Rose Webb today, who's the chair of the HARASSMENT Executive Council. Rose was formerly Deputy Secretary of the New South Wales Government Department of Better Regulation and allegedly retired recently, but now finds herself working full-time for free for the HARASSMENT. So welcome, Rose. For those that don't know me, my name is Martyn Campbell. I'm the SA convener for the SA chapter of the HARASSMENT, a member of the National Executive Committee. I'm also the head of SafeWork South Australia, the work health and safety regulator here, the chair of the heads of workplace safety authorities, which is the collective group of safety regulators in Australia and New Zealand, and the Secretary General of the International Association of Labour Inspection. And it's my honour to facilitate the discussion today. So we've got two fantastic speakers to open our chapter, both very senior executives in government and regulation, and highly respected leaders in their field. But before I introduce our speakers, I just thought I would touch on a few points about our webinar. So all of ANZOG webinars are recorded and will be made available on the ANZOG YouTube channel within the next 14 days. We'll be using the question and answer function on Zoom for any questions. So I do encourage you to use this, and we'll leave plenty of time at the end to ask questions of our speakers. If you do see a question that you like the look of, then please upvote that, and that will elevate it higher in the queue. And myself and the rest of the team will keep track of that, and we'll attempt to get through as many questions as we can. But if we don't answer all of them, then our presenters have very generously agreed to answer any questions afterwards in writing. So the plan for today is to listen to both of the presentations and then open up for a conversation. So after the presentations, we'll have a panel discussion. Both presenters will share their perspectives on pros and cons of an agile approach to regulation. And after that, I'll open it up to the audience for some questions. Now, given this is a hybrid event, during the live webinar section of it, we'll be taking questions from the online component only. And then following the end of the live stream, we'll open it up for the audience here in Adelaide to ask any questions of our panel. So Kate Jenkins is Australia's Sex Discrimination Commissioner and a member of the Australian Human Rights Commission. Her purpose is to advance gender equality consistent with the Sex Discrimination Act and the Convention on the Elimination of All Forms of Discrimination Against Women. Kate is currently leading several projects, including action to implement the Respect at Work National Inquiry into Sexual Harassment in Australian Workplace report, the Australian Human Rights Commission's collaborative projects on cultural reform with both the Australian Defence Force and the Australian Federal Police, and the independent review of the Commonwealth Parliamentary Workplaces. And if that wasn't enough, she's also the ambassador for the FIFA 2023 Women's World Cup. So prior to joining the Commission, Kate spent several years as the Victorian Equal Opportunity and Human Rights Commissioner, 20 years as lead equal opportunities partner with Herbert Smith Freehills, and many years serving on boards of Berry Street Victoria, Hyde Museum of Modern Art, and Carlton Football Club. Our next speaker is Sarah Court. Sarah commenced as the Australian Securities and Investment Commission Deputy Chair on the 1st of June 2021. But prior to that, joining of ASIC, Sarah was Commissioner at the Australian Competition and Consumer Commission between May 2008 and May 2021, where she contributed to strategic leadership, corporate governance of the ACCC, and decision-making across a range of complex economy-wide legal and economic issues. So Sarah's got extensive experience in government legal work, including compliance, regulation, restrictive trade practices, mergers and acquisitions, consumer protection, and law enforcement litigation. And having worked as a senior lawyer in the Australian Government Solicitor's Office, working with Australian government agencies to provide advice on complex and sensitive legal matters, and previously held board positions at the Law School and Centre for Regulation and Market Analysis at the University of South Australia. So having seen that, I wondered what I've actually done with my life, see what these two presenters have accomplished, and it's with great pleasure that we welcome them here today. So with that, I'll hand over to our first speaker.
Thank you very much. And hello to the online audience. And I'm very excited to be in Adelaide for the first time in about 3 years. So hello to the people in the room as well. I'll start also by acknowledging the traditional owners. I'm happily on the lands of the Kaurna people and pay my respects to their elders past, present and emerging, and also acknowledge the lands that you are on. As I said, I'm grateful to be here and particularly significant to be at the launch of the South Australian chapter of NRCOP. Anyway, you guys know the language, so that's an important event as well. And as Sex Discrimination Commissioner, I also love coming to Adelaide. Whilst I know there are great men here, Adelaide has a history, in my view, of deploying on Australia some of the most dynamic women we have in this country. And I think of Natasha Stott-Despoja, I think of Tanya Hosch, I think of so many others, Sarah Court, Annabelle Crabb. There are so many amazing women that are deployed across the country. And I know this is a place where women first got the vote. So what a great state it is. So can I go to the next slide? So my objective today is to give you an overview of the Respect at Work inquiry, and particularly in the conversations, I'm sure we'll tease out how regulators relate to the work, or what the findings were in relation to regulation of sexual harassment. So just reminding you of the background, in 2018, off the back of the start of a global Me Too conversation following the Harvey Weinstein allegations of sexual harassment and actually sexual assault, the Australian government supported the Australian Human Rights Commission to conduct a national inquiry on sexual harassment in Australian workplaces. So we conducted that over an 18-month period. 10,000 people were surveyed as part of our national survey. We had 60 public consultations, received 460 submissions, and also received some economic modelling and looked globally at what was happening across the world. And the report was tabled in Parliament on the 5th of March 2020, which some of you might remember was actually really pretty much the last sitting day before everything from our parliamentary agenda shifted towards COVID. So that was launched, and I do remember one of my fellow commissioners, Ed Santo, saying to me in the period after that, Kate, you have worked so hard for this and it's just disappeared. Like, I'm really sad that, you know, kind of all that hard work's come to nothing. So 2 years on, I can really confidently say all that hard work has not come to nothing. And since that time, there has been a constant conversation about sexual harassment issues, including issues involving the Vice-Chancellor at the University of Adelaide, issues involving the High Court, so issues involving public institutions as well as organisations like the AMP, kept the issue of sexual harassment and actually violence against women on the agenda. And the last 12 months has been a particularly active continuing conversation. So the government's formal response to the inquiry was delivered on the 11th of April 2021. And whilst it's very government words, basically they accepted all of the recommendations in whole, in part, in principle, or noted. And there's a particular reason for that language. But notwithstanding some of the social media, most of the recommendations have been implemented or in the process of being implemented. Next slide, please. I'll just give you a really super quick version of the findings, because I'm particularly interested to talk to you about how regulation, how the laws and the regulators have come together as a result of these recommendations. So the bottom line is we've found that sexual harassment is a systemic issue across Australian workplaces, despite the laws being introduced in the Sex Discrimination Act in 1984. We found in 2018 that 1 in 3 Australian workers had experienced sexual harassment, but we also found that there are particular groups that are more vulnerable and particular industries that have more risk factors. We found that the current system is largely driven by a complaints-based system. However, consistently over the 20 years we've been doing surveys, we found that only 17% of people who've been harassed would and do make a complaint. So a system that is driven by the courage of victims to come forward is not one that has really been properly advocating for prevention. And so a lot of our recommendations were pushing that obligation towards employers. We found also that sexual harassment has a high cost. So the Deloitte Access Economics modelling found that in 2018, conservatively, sexual harassment cost $3.8 billion to our economy, and most of that was borne by employers. Next slide, please. So we made 55 recommendations across a range of areas, including improved data and research. And I'll just let you know the next national survey is happening this year. And in fact, one of my colleagues here, Adele Tay, who is incidentally on secondment from the ACCC to work with us, is supporting us in doing that survey. We made some recommendations about primary prevention, and that's that philosophy of looking at education, media, and things that we can do to prevent the abuse, violence against women before it happens. A new legal and regulatory framework, which I will speak to shortly. Better workplace prevention and response models, so real guidance for employers on what they should be doing. So there is no question there's a huge appetite for change and doing things better, and a recognition that waiting for complaints isn't the best approach, but really looking for guidance. So we gave some guidance on that. And finally, better support, advice and advocacy avenues. And the advice part definitely involves regulators as well. This idea that someone could call one of us, the Human Rights Commission, the Fair Work Ombudsman, and depending on who they call, they'll get a different answer to what their rights are and what the situation is. So recommendations about how we can bring those together to make sure there's no wrong door and the answer is always the same, and it's national and it's comprehensive. Next slide, please. So I've mentioned when we came to do this, the opportunity, it was a national inquiry. I didn't have the hopeful expectation, but I knew our job was to really describe what was going on. As Martyn said in his intro, I had been an employment lawyer and I've been doing sexual harassment cases, which were largely the same since 1993 is probably when I started doing them. So I did have a conversation with my team of, okay, let's just pretend we could do anything we wanted. So if we could just start again, what would we do? Would there be a sexual harassment commission like the Transport Accident Commission? What would we do? Our conclusion was, in Australia, our workplace laws have lots of value, are strong, our regulators are strong, but on sexual harassment, there was a real lack of coordination, consistency, and also even understanding. So one of our conclusions were that sexual harassment created a risk to health and safety, and that notwithstanding that safety regulators had started grappling with psychosocial disabilities or injuries, that really they had not stepped into this space. We found that lots of people for workplace grievances would go to the Fair Work jurisdiction, not to the Human Rights Commission. And ultimately what we found was there were 3 regimes that needed some tightening up, But actually, if we would work better together, share our skills and expertise, we could deliver to the Australian people and to workplaces a much better system. So that it wasn't there, it was that it wasn't working as well as it should be. Our recommendations included better coordination and collaboration, and also some recommendations about filling some gaps, particularly in the Sex Discrimination Act. And some of you might know the Fair Work Act now has a stop sexual harassment jurisdiction. So some extra bits, but basically we were saying if these regimes could work together better, we could actually deliver what the Australian worker expects and what employers need. So next slide, which is the last one. So I was just going to, I did that slide, so that's why the bottom's yellow, because I don't know how to do, that's meant to be blue, just take that as given. So I just wanted to pull out just a couple of the things that have happened since this report came out. Firstly, that most of the recommendations have been implemented or are being implemented. If I just jump around, we've had one tranche of legislative reform, and the second major tranche is out for consultation right now. So I'd encourage anyone who's interested, and particularly who wants to support the positive duty for under the Sex Discrimination Act, to engage in the Attorney General's Department consultation. If you just Google Attorney General consultation respect at work, you'll find the discussion paper and a really good update on the progress. The other things that I wanted to mention that are relevant to this group is the Respect at Work Council. So this was a really central recommendation, and it was established 12 months ago in March 2021. It is the collaboration basically of the regulators with support of associate members that represent the voices of workers and employers to keep us honest, and also to remind us what the main game of this is, which is how are we delivering to the community. So Martyn is one of the members as head of the heads of workplace safety authorities. The members as regulators include the Human Rights Commission. I'm the chair, but also a member from ACRA, which is the Australian Council of Human Rights Agencies, so state and territory, workers' comp heads, safety heads, Fair Work Ombudsman, Fair Work Commission, and SafeWork Australia, as well as the Workplace Gender Equality Agency. So it's kind of like a dream collaboration in terms of workplace regulators, but it's also just bringing together all the complexities of state, territory, individual agencies, Commonwealth agencies in 3 different jurisdictions, plus a data collection agency. So it is fun at times, and it has made a massive difference, not just on what we're doing about sexual harassment, but also more broadly how we can work together. So I'm very happy to talk about those things. The other mentions, I guess, is that there's been some action on different support, advice and advocacy, different other recommendations that are implemented, and state and territory engagements through the Attorney Generals to look at how our laws can line up better and what changes need to be made at that level. So I will leave it at that point and hand back to Martyn or Sarah, however this transition is happening. Thank you.
We'll hold questions for them, and we'll get to those shortly. But in the meantime, I'd like to introduce you to Sarah Court and to welcome her to the lectern.
Thanks, Martyn. Good morning, everyone. I would like to also acknowledge the Kaurna people as traditional custodians on the lands on which we are meeting today. And I'm very grateful for the opportunity to participate in this session today. It's exciting to be in South Australia for the opening of a Regulators chapter. I'm very used in my roles at the ACCC and ASIC to be addressing rooms full of business people who are looking at me with daggers in their eyes with very hard questions. It's often slightly uncomfortable. So how exciting to be in a room full of regulators in person. So thank you, Rose, for the invitation. And thank you. Also, I wanted to acknowledge the important work that Kate has been doing. It's really a privilege to share the podium with you, Kate. We haven't met in person before, but the work that you and your team are doing to advance the interests of women and women's safety is just so important. So thank you on behalf of all of us. Now, I was asked to talk today about emerging regulatory issues from a South Australian perspective. And when we were chatting about the session earlier, I had to confess to feeling somewhat of a fraud in that regard, because while I am a regulator who very happily lives here in Adelaide, I have spent the better part of the last 15 years on planes going east in order to do regulation in my chosen area. And of course, it doesn't have to be like that, of course. And I know we've got an online audience from all around the country today. So there will be people participating in the event today that are working in regions that are not central areas. And I hope that my reflections today will be useful to them as well as to those of us who are here in Adelaide. And there are three emerging issues that I have chosen to reflect on, prompted, I think, by my relatively recent move from the ACCC to ASIC. There's one slight correction to Martyn's introduction on my CV. I think, Martyn, you referred to me as being at the ACCC since 2008, which I think would count 23 years. I am the longest serving commissioner at the ACCC, or I was, but it was only 13 years. It was 2018. Now, the three issues I've chosen to reflect on are firstly, the need for strategic enforcement. Secondly, the importance of communication as a regulatory tool. And thirdly, how important it is for regulators to work together to address consumer harms. And it was interesting listening to Kate's comments there on that importance of regulators working together. And I should also say, perhaps put a disclaimer or a caveat, that these are very much my personal reflections, as I say, having moved really from one regulator to another. So firstly, the need for strategic enforcement. Now, that word strategic is bandied about in all sorts of contexts. It's got a bit of management jargon to it, I confess. And so I want to talk about what I mean when I use the word strategic important. And it's in the context of, in my experience, the most difficult decisions for regulators to make are not what cases it takes on or what matters it investigates, but rather the difficult decision is what you are not going to do. Because it's there in that vast array of issues and problems that a regulator just simply cannot get to, cannot investigate, that the biggest risks for a regulator lie. And so I think, well, what does that translate to in practice? It means that regulators have to be very targeted, very clever, dare I say, strategic in their case selection, because they can't take on all cases. It means that those cases that we do investigate or choose to take on have to give us, and I do hate this phrase, but have to give us the biggest regulatory bang for our buck. We need to be able to use the cases that we are able to take on to inform the market, to inform companies, and to deter conduct more broadly in the sector. And in the ever-present context that regulators face of reducing budgets and budget pressure, this case selection and matter selection becomes all the more stark. And just to put some flesh on that, to give an example from my time at the ACCC, when we were faced with industry-wide conduct that we had concerns about, all else being equal, we would unapologetically take on the largest player that was engaged in the conduct. So that meant we sued Telstra all the time. We sued Medibank Private, we sued AGL, just to give a few examples. Now, those large firms did not welcome our attention, and also said, look, this is unfair. Everybody else in the sector is engaging in this conduct. Why are you selecting us all the time? There were two reasons that we took that approach. Firstly, because we felt that because those large players had more consumers or more members that were affected by the misconduct, it was important to choose areas or industry participants where most harm had been caused. But perhaps even more importantly, it was because if we took on the large firms, the big players who are engaging in the conduct, it sent a very clear message to other participants in that sector that the conduct had to stop, that it was not conduct that could continue. And being on notices to that, it meant that if they did engage in similar conduct in the future, the ACCC would come calling very quickly. The other thing that strategic enforcement means to me is that we need to be bold as regulators. The transition from lawyer, I should say, I was 15 years a litigation lawyer at AGS, and the transition from lawyer to regulator, I must say, was not a natural one for me. Most of my legal career at AGS was spent working out how to defend matters when people were suing the Commonwealth in all sorts of ways. So as a litigation lawyer, you're constantly trying to find the holes in a case, the weaknesses in the evidence, where the problems are going to be, what the risks are, which means, of course, that when I first started at the ACCC as commissioner in a completely different role, I brought that same approach to considering the matters. How is this going to go wrong for us? What's it going to look like when we lose this in court? But I learned over time a regulator can't take that approach. You can't just take the easy cases or the low-hanging fruit or only those matters that you're most likely to win or against those respondents that are unlikely to defend. That's not doing the job, in my view, because the job of a regulator is to test the law, to make sure it's being used to its fullest extent to protect those who it is designed to look after, and to take risks and take those hard cases where the outcome may be uncertain. Now, this is not easy as a regulator, and we all know the tightrope that regulators walk between the regulated community on the one hand, who are rightly concerned about regulatory burden or regulatory inefficiency, and then on the other hand, the concerns of those who are there for the laws to protect. And their usual complaint is, where is the regulator? Who's looking after us? Why are you not doing more? The strength of the views held by both sides of that spectrum tends to lend to criticism in both directions for regulators when we fail in court or when we get something wrong, when we miss an issue. And that can sometimes result in regulators being timid or keeping their heads down and out of the spotlight, but that's not doing the job. Which brings me then to the second issue that I wanted to address, which is communication as a regulatory tool. And when I say communication, I'm probably talking largely about the media. And I've had a very long and slow conversion to the importance of the media as an essential regulatory tool. As mentioned, when I was at the AGS, the aim of AGS lawyers was to keep their clients, who are usually Commonwealth government ministers, off the front pages of the newspaper. So a KPI was not being reported on in any way. And I came to the ACCC with that rather media shy approach. I was deeply uncomfortable with media interest and attention. Indeed, I considered media interest or chasing media attention to be a little unseemly, dare I say, populist, which I used in a very disparaging way. And that is, I think it was fair to say that I, along with some others at the ACCC at that time, felt that populist issues were not the real issues and that we as regulators knew what the real issues were and what we should be doing. But over time, influenced by a very media savvy and, dare I say, media hungry chair, who I worked with very closely for many years, my view did change. And I was staggered at the ACCC to find that some of the matters in which we received the most public kudos, the most interest from media and from parliamentarians as well, were not for things like global long-standing cartel agreements, which consumed years and years of staff time and resources, but for things like the issue of infringement notices for the mislabelling of oregano, which ended up being a front page newspaper story. And we got enormous kudos in relation to this. For our prosecution of Coles for selling par-baked bread. Who would have thought? And interestingly, the discussions around the commission table when we were making decisions about these issues and whether we took them on were really divided. There was a real strength of views on both sides about, is this really the kind of issue that taxpayers want their money spent on? Surprisingly to me, it was. suspected misconduct by hearing aid sellers, where we took an unusual approach, which wasn't a traditional court case or infringement notice, but we issued a short report about some of the practices that hearing aid providers engaged in. We didn't even name the companies in question. And again, front page news and a current affairs story, and great kudos to the ACCC for taking on these serious issues. So I've learned from all of that, and a lot of our enforcement work and the way that we explain what we do is, of course, it's about deterrence. We are trying to deter people and companies from contravening the laws that protect our markets and protect consumers. And the very basis that the courts recognise for the imposition of pecuniary penalties is specific and, more importantly, general deterrence. So obviously our work cannot be a deterrent if no one knows about it. And I guess that is where my conversion to the media has come about. I still am slightly uncomfortable about it. It still does seem a little unseemly, but it's been interesting to come to ASIC and find myself being the person arguing for more use of the media and telling our story in a different way. Turning to my third issue, and that is the importance of regulators working together to address harms. And I think this really is an emerging issue for all of us. And one of the things I've been reflecting on since I came to ASIC is the extent to which regulators have overlapping jurisdictions and the importance of effective regulatory outcomes, or the importance for effective regulatory outcomes of regulators being able to work together in a genuinely open and transparent way. Now, there are some circumstances where that is necessary and clear and obvious. For example, both the ACCC and ASIC operate under what is called a one law multi-regulator consumer protection framework, in which the Australian consumer laws are administered and enforced both by the ACCC and ASIC and by every state and territory fair trading agency at the local level. So in that circumstance, the need for coordination and consistency in approach is clear, because the interpretation of those laws, those critical laws, by one agency can have an impact on the work of every other agency that is also administering those laws. Companies that are engaging in conduct across multiple states can also be subject to competing investigations in relation to the same conduct. So these were arguments against having this one law multi-regulator model at the time back in 2010, but those agencies all work very closely together to ensure that we have a joined up approach. But there are other areas where this overlap is less immediately apparent. And there's been a couple of examples in my short time at ASIC that have really crystallised this issue for me. So in one matter in Western Australia, that of the Sterling Group, a large number of mostly elderly consumers invested very large sums of money into what they understood to be a long-term residential lease. And as part of that arrangement, these consumers would enter into this long-term lease and they would become the tenant. So as in their role as tenant, they were subject to the Western Australian state tenancy laws. But as part of this arrangement, unbeknownst to these tenants, they were also required to pay a lump sum into an investment product, and they thereby became an investor. The return on this investment was intended to be used to pay their rent for the duration of their lives. So they were told that the returns from this invested capital would pay all of their rent due. Now, most of them were not aware that they had made an investment in this form at all. Now, the complicated financial arrangements ultimately failed disastrously. Enormous harm's been created or resulted for these consumers who are described as tenant investors, as I say, who had no concept they had invested in a managed investment scheme at all. ASIC's jurisdiction is enlivened by the investment part of this arrangement. The WA Consumer Affairs jurisdiction is enlivened by the tenancy aspect. Somehow, these elderly consumers, many of whom are now tragically homeless, fell between these two sets of regulations, and there's been a recent Senate inquiry examining these issues and how the agencies interplayed, and we are carefully reflecting on the lessons learned from that. that reflection, of course, is of little comfort to those who have been left so badly off as a result of the matter. Another really recent example, which was in the media this week, and it's interesting that Rose is here, but this matter involves vulnerable Indigenous consumers who have for many years made payments to a funeral insurance provider that has recently become insolvent. And there are 4 different funds, insurance funds involved. Now, the New South Wales Office of Fair Trading is the prudential regulator for 3 of those 4 funds. And ASIC has taken legal proceedings in relation to the 4th fund. The liquidation means now that members from these very vulnerable consumer groups, there's about 17,000 of them, have been paying into these funds, sometimes for decades, and now they are unlikely to see any return for that investment, which has led to extreme distress in these communities. So again, by raising this, I'm not trying to lay the blame at the foot of any particular regulator or any other part of the system, but just to acknowledge that the complexity of the interaction between prudential regulation and conduct regulation, and between the state agency and the Commonwealth agency, I suspect may in the end be found to have contributed to these current circumstances. And so one of the things I think we need to do in the aftermath of these matters is to really have a close look at how the agencies have interacted, the quality of the communications, the openness and transparency with which we engage. And I really do think that this issue of cross-agency responsibility is likely to continue into the future. So with that, I've probably gone over my time, Martyn, but let me pause there and happy to have a discussion. Thank you.
So now we'll get into the panel discussion part of our session. And I might actually start with you, Kate, and then but sort of lead into the question around sort of how regulators remain agile or become agile. So Kate, from your perspective and the work that you've done, sort of how do you see the work that stems from your report around sexual harassment, discrimination, violence be regulated in the future? What does that look like for you?
So as I've already mentioned, Martyn, and I really, those 3 points that you raised, Sarah, I couldn't agree more with, and some of that, particularly on the media, has been part of my journey as well. But that last point that you're talking about and how regulation will happen going forward. So as I described, my vision is that these laws could work together and the regulators could work together. That is the vision and the aspiration. And that last example you gave, that really was the story of the Respect at Work inquiry, that actually we have the laws that are in place that if they were working well, they should be doing the work that will reduce sexual harassment and hopefully ultimately prevent it. If I go off that, Martyn, just sort of bounce towards the council. So the council, the Respect at Work Council is exciting, not just for sexual harassment, but this idea that we would bring together some of the key workplace regulators, the key regulators in one group. So, there is a dream, and it happened at the time we were doing that inquiry, that all the federal agency sat under the Attorney General's department, and that is a relatively recent, but, from a practical point of view, just having everyone in that same portfolio just seemed to immediately create a lot better opportunities. But something that I've talked to you about, Martyn, is in terms of just put aside the legal changes, getting us to work together, there is 2 or 3 things that even though, so the idea is we work together, collaborate, collaboratively, consistently, coordinated. That everyone agrees with that. There is no one across the whole country that doesn't agree with that. So then we're in practice. So we're at the next level. I'm really great. We've got this council, everyone's really engaged. And in fact, there's all these other spin-off benefits. Like when Martyn asked me to speak at something, I just say yes, because I know him and this is a great opportunity. So if I think about what are the kind of 3 next layer where everyone says we want to do this, and then they're like, but just don't disrupt us from how we already do things. So there's probably 3 things that I would say, and this mightn't be answering your questions, but it's something I'd like to share with you that I've observed even from the Human Rights Commission, which doesn't have the same powers as many of you. So one is that we've said there should be no wrong door. If someone who's experienced sexual harassment calls one of us, they should be getting information. Well, even within my agency, there's great discomfort to talk about what the laws in another jurisdiction. It is not our job to explain how the Fair Work Act works. From a victim's point of view, them sort of only having to understand what each regulator does and then call each of us, it's just crazy. But it's not that no one disagrees, but when I've spoken even within the Human Rights Commission, they're like, we actually can't. You want us to tell us we can't do that. So that's number one, is just, are we allowed to even talk about what someone else does, even if, we're not the expert? Number two is the expertise. So one of the things that happens is, because it's easier to stick within your own regime, when we came out with this report that said actually the safety laws apply, I'm being a bit mischievous in saying this, but a lot of the safety regulators, some had said already, well, if it applies, we're not funded, we don't have the expertise, please don't give it to us. But it was kind of like, well, we're not giving it to you, you have it already. And then the next response was, okay, leave it with us. Human Rights Commission out the way, we've got this, right? So I'm kind of, there was a point where I'm like, no, it's been our laws for, since 1984. It's great that you have those mechanisms, but can we work together? And that's been with great intent, really challenging, because the regulators in the work health and safety, they're often ex-coppers, or, and we're kind of like, you need to know about trauma, you need to understand the definition. And they're like, we don't have a code on that. Well, that's not what we do. So the next is to say, we're going to try and work together. We're going to try and share expertise. And that is something that we can do, but that's again outside. So that means, and one of the things as well as education that we're doing, which is part of the respect to work. So the Human Rights Commission is literally developing training for all the safety regulators, Fair Work, and that's going, and judges as well. That's going well. But another thing that we have done at the Human Rights Commission is, when we were doing that parliamentary inquiry, we realised we needed someone with safety expertise, particularly on bullying, and we had a secondee from Comcare come across and work with us for 7 months. It was the greatest thing that the Human Rights Commission's done for that piece of work. But also it was great for that person who's now back in Comcare, able to bring that. And right now I've got someone supporting us, as I've mentioned, Adele from ACCC. That the reality is, this might seem strange, bedfellows, but from a regulatory point of view, really helpful. The last area that I can already see, even though everyone agrees, is gathering data. So what we said is, there's lots of sexual harassment that happens that goes to different regulators, some that goes to the work, the safety regulators, some goes to workers' comp, some ends up in an unfair dismissal, some comes to state and territory. So we've got a project, which I thought would be easy, but you would have known is not easy, where we're saying, well, we want to collect data. Let's work out a minimum data set of numbers of complaints, outcomes. What would we want to know? So computer says no is basically, everyone's like, we agree, but we don't have the right code. It will take 12 years to get the right code. If you need us, we'll do it manually, but we don't have the people. Whatever a TOC code is, I'm learning about. Sexual harassment's not defined. And there is no one in this system that doesn't think this is a good idea, but the practicalities about it. So I think you gave, there's been examples of just everyone. I know you've got examples too lining up. So those, so what do I see? I think we can get there. And I actually think that these are little things, but they're big things. And I think there's a lot of will. But sometimes, so I just encourage everyone to then kind of back out and come back and think, but how can we solve this problem? Because there's super smart people in this jurisdiction. There is now the political and the community will to fix this. So that's the best environment for us to find different solutions. it's not the will, it's actually just the systems that are quite often, and then there is a degree, including in our agency, of arrogance that we know this better than you know this. And together, it just opens up such a better response. So yeah, that's a long way around about 12 questions that you didn't ask me.
No, but I knew you were going to answer them. Thank you. So, that leads us sort of into that sort of multi-discipline, multi-agency approach. So, and about being agile and agility and responsiveness. So I think regulators now are working together more than they ever were before. So from your perspective, Sarah, what do you see as sort of the first steps on making an agency agile or being agile, or what are some of the barriers potentially that are stopping agencies from being more collaborative?
No, it's a good question, although I have to, again, give a disclaimer, that word agile, Martyn, it always makes me think of regulators doing trampolining or something. But it's interesting listening to Kate's reflection on this whole issue, that it's not a lack of will. There are some systemic and structural issues that prevent a whole range of things. I mean, if I think about just an example at ASIC at the moment, so following the Financial Services Royal Commission, one of the law changes has been for there to be significantly increased what's called breach reporting from financial institutions. So there is, hundreds of thousands of these kind of technical breach reports that are now going to be making their way to us, and we need to find something to do with all that data. So one of the challenges, I think, for a modern regulator is just data, the volume of it, capacity, skills and the like. But within all of that data, there's going to be a whole lot of information that, for example, would be really useful to other regulators. And one other regulator that it might be really useful for is the ACCC, who does a whole lot of work on scams, for example. So in a logical world, from a consumer-facing approach, you might say, well, great, we're both regulators, we're both Commonwealth agencies, why don't we just whack all the data, all this breach stuff over to you, you have a look at it and you interrogate it for the purposes of scam reduction. Scams are, one of the biggest issues facing consumers at the moment. Now, of course, we can't do that because of the statutory provisions, because we're not able to share information that is acquired compulsorily in that way. And then you've got the whole Privacy Act. And it is remarkable to me how frequently we want to get agencies working together, and there's just a Privacy Act issue that we can't share anything about anything. So I think these are just really wicked problems, because privacy issues matter. Statutory compulsion of material from any agency or person matters. It shouldn't be able to be disclosed willy-nilly. We all agree with that, but we're not able to efficiently address some of the key harms as a result of some of these structural issues. I think that's the first point. And just picking up on something else, Kate, that you were talking about, I think the other challenge for us as regulators, and it really goes to my last point as well, is this might sound a bit, what's the word, a bit wishy-washy or a bit hippie-ish or something, but this is all about, it seems to me, relationships and trust between regulators from the highest levels down to our teams that are working on the ground. I'm very familiar with that kind of sense that we know the right way to do it, and we're the best regulator, and that nobody else quite knows how to do this. And I think we really need to start openly exploring and working out who is best placed to deal with this issue. What is the issue? Who's got the skills? Who's got the tools? Who's got the legal regime? Who's got the resources available at the moment to jump in and deal with it? And I think, I was talking before examples between Commonwealth agencies and state agencies. It's even hard between Commonwealth agencies. So I think, that's why networks like this are so important, right? Because you start engaging, you start talking, we start sharing stories and start understanding we're all facing the same kind of issues. And I think once those relationships and we increase familiarity about what each other does, it can only be a good thing.
And I think more than ever, certainly from my perspective as safety regulator, we're working more collaboratively with agencies than we ever had before. And as we sit here, we have safety investigators sitting in a major incident room with South Australia Police, working collaboratively on a sexual violence case. We've got cases with the EPA where we're working collaboratively. And I look around the room and see some of my friends, some of the regulators, and we're all playing in the same sandpit and sometimes at the same time. So being able to show a bit of organizational vulnerability and to say, I'm not comfortable that actually we're the best people to deal with this, but we can contribute, is a really good step forward. So I might go to a question online, which is directed to Sarah. So this is from Grant Pink, who's actively involved in the NRCOP and a long-standing friend of ANZOG. So Grant was talking around your reference to strategic case selection, and that the words targeted, clear, strategic can mean very different things to different regulatory practitioners. So he's asked, do you have any tips on assisting regulators to better connect and understand what those concepts mean collectively?
Yes, I think I know the name, Grant Pink. So hello, Grant. I think we may have met in a former life. Look, I think that's a very fair comment. I think strategic can be in the eye of the beholder, if you like. But I think there is something in that. I mean, I guess the concept I'm trying to get across is when you're faced with an avalanche of matters and complaints and issues that you could look at, and often there will be a lot of noise around from various groups about what it is that you either take on or that you don't take on. I just think that critical decision about case selection is, and thinking about at the time that you're taking on a case or taking on an investigation, not just because, oh, look, there's this misconduct, so we better have a look at it, just sort of in a rote way. Complaints come in, okay, get these two people to have a look at it, issue some statutory notices, off we go. I think my suggestion or proposal is that we step back and we have a look at it and say, well, in a sense, what's the regulatory utility of us taking this on? What's the bigger picture? What are we going to do with it at the end? So that you sort of start with the end in mind, thinking, well, if we took this case on, if the conduct is sort of what we think it might be and we took it on, this is how we're going to be able to use it. So this is the kind of media release that we would write. These are the kind of people that or groups or industry sectors that we go and talk to about it. This is the narrative around it from the human perspective. This is what we'd be saying to the rest of the sector about if they don't change this kind of behaviour, then this is what we're going to come and do. So it's just really trying to think more holistically about what would a good outcome look like. And I think the other thing that I didn't touch on, but is a constant bugbear, I'm sure, of many regulators in the room, is this whole issue of timeliness. How can we get more timely outcomes? And again, there's so many different ways to look at this issue, but many investigations or matters that I've been involved in, both at the ACCC and ASIC, are genuinely continuing for years, years and years. So the conduct might be back in, 2012, and criminal charges are just being laid now. And I think that's really challenging for the public to understand. Have you let us down by not being able to action this more quickly? And so one of the things that I'm constantly asking our teams to think about is, do we have to take, the entire matter? Do we have to take on every piece of the wrongdoing? Or is there a bit of it that's the most egregious that we've got evidence on and we can be in court quickly, within a year, for example? Well, then that's another part, in my view, of what being strategic is.
Fantastic. Thank you, sir. And just on that, Grant, I'm going to shamelessly plug your book, which helps regulators define those concepts. So if you haven't had a chance to read it, then please do.
Maybe I should have read the book before I asked the question.
Okay. I'll just take another question online, which is in relation to research by Ipsos and the Global Institution of Women's Leadership. Showed that 1 in 5 people in Australia think women who say that they were abused often make up or exaggerate the abuse or rape. And how does that impact on how we regulate these issues? And how can regulators assist in shifting those attitudes? Kate.
So everything we're talking about is all interconnected, and that also includes that discussion about communication, taking the opportunity. I think we're a very tiny agency, so a lot of both what the Human Rights Commission does, but also the activity for advancing gender equality is, that there is inequality across almost every part of our community, but except for education, I would say. Sort of generally we're good at educating women and girls, but other than that, in terms of economic security leadership, there is so many issues. The reality, just bouncing off that and then coming to that data, is that the model for advancing gender equality and preventing violence against women, which is reflected in Change the Story, which is a national framework that we have in Australia, is all about choosing high impact settings for change, recognising that there's a whole lot of things. But if anyone who knows the work I've done, I really, at the start of my term in 2016, chose workplaces, sport and education as the locations, and Parliament then has really definitely become another high impact location. So that's the first thing, is in terms of gender inequality, actually we know that it is not my job to change people's attitudes, because I can't educate every person in the country. So a lot of the work I do is about changing the structures and the systems. But the reality is, we know underpinning, both through that recent survey, which gives us a global comparison, doesn't shock me, but it really says that Australian attitudes, the broader attitudes, particularly of a portion of men in this country, are really out of line with kind of common sense, aside from anything. And so the interesting thing about that piece of research is it tells us that particularly Australian men, and I haven't got the exact number, but have even higher than other Western countries attitude that women are doing this to just, they're making it up to take advantage. And this simply, the evidence is this is almost zero. It's very low number of women who are making these complaints up. In Australia, we have some really good data. So if I want to encourage regulators to think about what, and then incorporate it into the work that you're doing, the National Community Attitude Survey, which is run by Anne Rose, which is Australia's national research organisation for women's safety, but Anne Rose does this National Community Attitude Survey, and it has the Australian data. And when you look at that, people's attitudes for gender equality, it really does tell us that we have some very deeply entrenched views, and those views mean that sometimes when you're moving forward, actually there's a whole population that's working very actively against what regulators, and particularly on gender equality, are trying to move forward. So the main thing I would recommend is just inform yourselves, because this data is really helpful, because even within regulators and around dinner tables as well, but don't women make this up? Like in terms of doing the sexual harassment work and even the Parliament work, I've had some conversations with people who are in or around Parliament, and they've said, yes, but, we've got to make sure that, kind of people are not being brought down by these false accusations. And in those conversations, I've said, you haven't read our report, have you? And that's because the report is not about false accusations. It's about all the environmental factors that create this increased risk that actually bullying, sexual harassment and sexual assault occurs. And so when I'm in these dinner party conversations where people are giving me very strong views about my report, of which they haven't read clearly, because I can tell from the conversation they haven't read it, my main encouragement for regulators is just go to the data, read it. And then when someone tries to have a dinner party conversation to convince you that women are out of control and that we're spending too much time talking about women, just a couple of data points on what the experience of sexual harassment is, or family violence, or online abuse, really is a helpful way to say, actually, no, your understanding is incorrect. So that's probably not even a regulator thing. That's just a normal community thing. And my sense in the last couple of years is the balance is tipping. So there's some people who will never agree with this. But there's a big group in the middle that are curious, and I think we're starting to get a real change of understanding, particularly in the last 12 months, that actually it does seem that there is some pretty bad situations happening, particularly for young women, but also for older women, and we should care more about it and not dismiss it as just a whole lot of kind of complaining.
Fantastic. Thank you, Kate. And I'm glad that I'm not the only one that has uninformed people telling me how to do my job. I'm sure there's a few of the regulators out there that have the same. And speaking of which, we have a regulator online who's put a question to Sarah. It says that you mentioned that as regulators, we're judged by the matters we don't take on. So he's interested in the panel's views on how you manage complainants where there is merit in the matter, but resources and priorities don't permit it to be taken on, particularly where there's a level of individual loss or harm.
It's an excellent question, and I think it's every regulator's dilemma in that we can't take on all matters, as I said. So I think for my part, one of the ways to try to manage that is to have a clear priority setting process within an organisation, to talk publicly about those areas that you're going to focus on, and then proceed to, properly address and take tangible actions in relation to those issues that you've identified. It doesn't solve the challenge of the issue of the person that has lost out. And in those examples, those sad examples I was talking about, I mean, there is no immediate answer in relation to those consumers. So I think listening to people, I think giving time to people to recognise their grievance. I mean, sometimes it's about being heard and about being recognised, but regulators don't have the resources to do that on an individual basis either. So I think I'll just recognise the question and wish that we all had unlimited resources to deal with those issues.
It sort of takes us back to the heart of the NRCOP formation and the work of Professor Malcolm Sparrow, which is about picking important problems and fix them. And regulators having processes and strategies in place to do that. And each one of those words is extremely difficult in its own right, because as regulators, you're right, there are things that we just can't do. And look, on that note, I might finish there. The webinar online event will end, and I'll just take the opportunity to thank you both for coming to our inaugural event and contributing the way you have. I really do appreciate the time. You're incredibly busy, so thank you very much. And I definitely owe you a very big one for your time here. And on that note, we'll thank everybody online and say goodbye.